Florida is now in session. Let all who have cause to plead draw near, give attention, you will be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Florida Supreme Court, please be seated.
Good morning and welcome to the Florida Supreme Court. Our first case today is Mosley v. State of Florida, number 2023-1091.
Good morning, Your Honor. My name is George Burden. I'm here on behalf of John Mosley, Jr. Mr. Mosley was convicted of 2 counts of first-degree murder. The jury recommended life for one of the victims and by an 8-4 vote death for the second victim. This is one of those Ring versus Arizona Hearst cases where it was after Ring, so he was in that window, so he got Hearst resentencing after 2015. He went through that process, and because of a Feretta violation during the Spencer hearing, this court reversed his death sentence for that purpose. We're here today to discuss 2 issues. The first issue has to do
Do
with
either of those issues have anything to do with the Spencer hearing or the remand?
none whatsoever, Your Honor.
Okay.
Absolutely none
Why
whatsoever.
isn't that a problem?
Well, because this court has the power and should exercise its power to do justice in this case, and it's laid out in the brief and with the first issue that, and this is something that's coming more and more common, where we have verdicts now from the jury, and they found no mitigating evidence whatsoever.
Well, what makes you think we weren't aware of that the last time we were here?
I did not do the initial brief in this case.
All right,
This was a
but
transfer
you have access to what we wrote last year, presumably.
Oh,
right?
yes, of course.
So what makes you think we weren't aware of the issues you're presenting now?
It wasn't raised in the initial brief that was
Well,
done by...
isn't that a problem for you if they weren't raised?
Well, of course. The learned Attorney General correctly argued that it's waived. Absolutely.
So then what are we doing here?
You want us to waive the waiver?
Yes. Absolutely. Because
Can you point us to a case that suggests that that's what we're going to do or should do, or that that's the law? Or are you just affirmatively asking us to make up something?
Yes.
Okay.
Oh, absolutely.
Okay.
Because if you don't do it now, it'll come back later, because it's ineffective assistance of appellate counsel not to have raised it before. And the reason that you haven't seen this before, we didn't have verdicts like this way back when. You wouldn't know what the jury was thinking, but here we know. They said there's no mitigation here, which obviously means they didn't pay attention to the judge, because the judge found 29 non-statutory mitigating factors. And so, you know, if you remember, the whole reason we have the death penalty, they set up this system where aggravating factors have to be established and mitigating factors for the purpose of narrowing the class and not being arbitrary. As this court is well aware, and you've heard numerous arguments that with aggravator creep and all that, we don't have that system anymore in this state. We just don't. You can't think of a way to kill somebody that you're not going to be death eligible anymore. So it has become arbitrary, and it's now even more arbitrary when the jury's even ignoring the judge's instructions. And at some point, this court has to address this.
What
issue.
evidence do you have here that we should rebut the presumption that the jury, in fact, followed the judge's instructions and, you know, heard them, but decided to come out another way?
Well, it speaks for itself.
What speaks for itself? Help me, because I don't see it.
They found on the verdict form no mitigation has been proven.
And you're saying there's no way for a jury to have reasoned to that conclusion? It's impossible?
Yes.
Okay.
Absolutely.
And the basis for that is?
That the judge found 29
so
non-statutory mitigating
when the
factors.
jury was instructed, were they instructed that the judge had found that those mitigations were uncontroverted?
Say that again, Justice Lamarck, I'm sorry.
I'm too far back, I'm sorry. When the jury considered the verdict, when they deliberated, did they know that all those mitigators had been found to be uncontroverted, and were they told you have to assume they're true? Something like that? I mean,
No, I don't believe they were instructed
so
that.
how does the jury know that the judge found them to be uncontroverted?
How do we know what the jury was thinking?
Right.
We know what they were thinking. They rejected the fact that any mitigation existed on its face by their verdict, which means they didn't follow the instruction because the judge said you must find mitigation if it exists in any way.
Let me ask you this, counsel. Does the statute require that they make a specific findings of mitigation? I know the statute requires that they consider mitigation, and they've got to make determinations on the aggravators, and then they've got to make the bottom line determination, recommendation. But there's nothing in the statute that requires that there be determinations individually about the aggravators, is there?
No, sir.
I mean, and the reality is that this verdict form and these interrogatories, the court had kind of gone off and done this, and then we figured out later that wasn't really smart, and we took a different tack. So this is in an area here where it's detached to a certain extent from the statute. So doesn't it have to be viewed in the context of all that?
Well, it's viewed this way. If you look at the two Georgia cases, Gregg and Furman, and then Lockett versus Ohio, if you put those three cases together, that's the support for this. To have properly constitutional death penalty sentence, these things are required. Mitigation of you're very familiar with Lockett. It's wide open as to what you can present in mitigation because of Lockett, and the standard of evidence is different for mitigation evidence. So it's inexplicable for why the jury didn't find on the verdict form that some mitigation evidence was presented. It's inexplicable. So the only conclusion you can come to is that they didn't follow the judge's instructions. And as you know, we get heightened due process in capital litigation. This is not a contract dispute. This is where someone's life is on the line. So it's a different scrutiny. And you guys can address this now, or you could address it later.
Well, we've got another case today that raises the same issue.
The one that follows.
But actually, it raises it in the context where it maybe isn't barred in the way it would be here.
No, I understand your statements about waiver, and it's true. It's absolutely true. And I just submit that judicial economy, you can deal with it now and tell the state and all the judges with these verdict forms that seems to be a mistake, to paraphrase you, Justice Kennedy, that we won't have this anymore. So that's why I raised it. I was totally, in all candor, knew that it's something that you may not want to address today, but I thought this court should be made aware of it, and you can choose to do as you wish.
What about your second issue?
Yeah, the second issue, the medical examiner in Jacksonville had dementia. At what point, evidentially, we don't know, but she certainly did. And they made a claim procedurally during the course of these interactions in 2018, 2019, that it's newly discovered evidence because they got, because of HIPAA, it's not easy to get people's medical stuff. Oh, they got it, and it showed that she did have dementia, and I think she actually passed from dementia eventually. And their argument is, well, if she had dementia, she's a disqualified witness under the evidence code 990.603. She'd be a disqualified witness. So how are you going to, it's not a case where you can get a substitute ME and look at her notes. If she had dementia, her notes aren't good either.
Let me ask you this, two parts about this. When this was dealt with below, an order was entered.
Yes, sir.
Why would I think that's anything other than a final order?
I think you can take that position.
That it's a final order?
Yes.
Well, if it's a final order, the appeal was not timely.
That's correct. Ineffective assistance also. Absolutely. But us as coming before this court, we can't ignore ineffective assistance. And, there's been a lot of change in that.
Well, let me ask you the second part. The second thing I want to ask you about this.
Yeah.
How in any way does the supposed mental problems of the medical examiner have any significance here when the medical examiner's testimony was so dramatically inconsequential?
Well, very easy. A great question. And the reason is...
I try to ask good questions.
Yes, Your Honor. The reason is because we don't know, because there's no evidentiary hearing. That's what we're fighting about here.
We do know. We know what she testified to, which was like the nothing. I mean, the tragic circumstances here
Yes.
of this incineration, but the result of that was that she gave what she testified to was not material. And so the idea that we don't know, that just seems to me to be fanciful, because we know what she testified to. That's on the record.
Oh, absolutely, but with an evidentiary hearing, you could be able to flush it out absolutely. And that's we're not saying
What's the fact at issue in that evidentiary hearing? What are we taking testimony on to determine whether or not it's true?
whether or not she was so impaired that what she did would not justify her testimony.
Tell you what, let's assume she was impaired. Now what?
Well, under the evidence code, she'd be disqualified as a witness.
Great, we disqualify her. Now what?
Well, how do you have a cause of death?
I still have a deceased 10-month-old baby in a garbage bag and an incinerated girlfriend, right?
Well, that's what that 15-year-old testified to.
No, I have those bodies, don't I?
No, sir. They never discovered the body of the child.
Okay, I have the body of, you're right, but I have the body of the girlfriend.
Yes.
And I have the testimony about the baby.
Based on what Mr. Griffin said about what happened. And so, like
Again,
I said,
the testimony as to the baby is unchanged by the exclusion of the ME, right? Mm-hmm. Okay. So it seems to me like, having worked through the logic and excluded the witness, we're still in exactly the same place, aren't we?
well, yeah, you could take that position, absolutely. But in cases like this...
What's the other position?
The other position is just have an evidentiary hearing to have full due process.
I think you're fighting the logic that you just walked into. I mean, I think you should concede the point here, which is that the hearing that you advocate for at the end of the day has no impact at all on the outcome of this case.
Yeah, I could see why you could say that, and quite frankly, this is a very challenging appeal to do.
No, and we appreciate that you're doing it. I just wish it were about the Spencer hearing.
Well, the Spencer hearing had the defendant's mother, his wife, and his two daughters testify. That's it. And they just said, said nice things about him. I mean, that's it. There was nothing else presented. I don't know what argument I could make to this court based on that presentation, honestly. It didn't make it less mitigating or anything else. And it should be pointed out, in a new penalty phase, the aggravation got more severe. They found hack in the second penalty phase where they didn't in the first. And I think that's significant. It's as you know, CCP and hack murders are weightier aggravators than any others. So the first penalty phase, they didn't find hack. So,
Let me
Well,
ask
I mean,
you.
it's, if you want to argue, but you're not arguing about that, because it's hard to argue about it given the facts here, correct?
yes,
Putting a
well,
baby in a bag and disposing of it in a dumpster, and then incinerating a woman, the mother of the child. That kind of sounds like hack to me.
I will concede it is hack, especially with the child victim. Absolutely. And so, anyway,
Well, of course, that's what. Well, yeah.
Let me ask you, I mean, I guess the issue that we're here on, pretty much is that we sent the case back on the question of Spencer hearing, because the trial judge at the time, right before the Spencer hearing was supposed to commence, the prosecutor informed the judge that, hey, we had this new motion from the defendant, and he wants to proceed on his own. So the prosecutor's kind of hinting to the judge, before you proceed to anything else, you need to take care of this. And the judge kind of just waved them off and proceeded to something else, went ahead and sentenced them to death, and then, you want to do that Spencer hearing now. So obviously there was an issue there concerning the defendant's right to proceed pro se if he wanted to.
yes.
So we sent it back for that. The only reason we sent it back is for the trial judge to conduct that proper Spencer hearing
Yes.
and to see what the defendant is. As it turned out, when it went back, now the guy wants a lawyer. So he changed his mind again.
Yes.
So, I mean, aren't we done? I mean, given the objective of what we
Yes.
had this case go back for?
You can certainly take that position, Justice LaVarga, absolutely. Absolutely.
Okay.
And with that, I will finish up and allow my opposing counsel to go forward. Thank you very much.
Thank you.
May it please the Court, Lisa Marie Lerner with the Attorney General's Office for the state. As this Court knows, it issued a very narrow remand only on the Spencer hearing. This is not a second appeal of the second penalty phase trial. And if the Court has no questions, I will rest on my brief.
I have a question.
Yes.
So since we've already wasted time with this remand that should never have happened in the first place, is there anything that we can do in our disposition of this that would address the questions that he says are going to have to be addressed in later proceedings? If we decide to overlook the fact that these issues that he's raised aren't really properly in front of us right now?
The evidentiary hearing issue, the Court, in an act of charity, took it on the merits and found that he failed to meet either of the Jones prongs for newly discovered evidence. And his reasoning was solid given the situation and the facts of this case. So that issue is settled as far as the state is concerned. In terms of the jury, jurors have a very limited duty in terms of mitigation. It's not the same as if they were aggravators. They do not have to find them beyond reasonable doubt. It is up to the individual juror to make what the Supreme Court has called a value call on whether a set of facts is mitigating or not. They may believe the facts, but don't find them mitigating. And we know that the jury followed the instructions in this case because we have that jury form, verdict form, where they go through each mitigator individually and tally how many jurors voted yes to find it mitigating and how many jurors voted no. And on a number of the mitigators, some jurors found it mitigating. So we know that the jurors followed the instructions and individually analyzed the mitigators. However, the jury as a whole found that the mitigators were not established, nor were they sufficient to outweigh the very weighty aggravators. And the verdict form shows that. Further, under our statute and Supreme Court law, the trial court has no obligation to adopt the jury's assessment of the mitigators. It has an independent duty to go and evaluate. The court is the sentencing body, not the jury in the state of Florida. So the court individually evaluated the mitigators, and in its role found 25 mitigators, non-statutory, that it gave weight, and 4 that it gave no weight.
So in terms of addressing that in this opinion, would your position be that regardless of the procedural issues waiver and exceeding the scope of remand, that there wouldn't be a need to address it in this opinion because counsel wouldn't be ineffective for failing to raise a meritless issue regardless?
Yes, and there's no ineffective assistance of appellate counsel because it's a non-meritorious issue.
And I can't remember, did the form distinguish between whether the underlying facts were proven versus assuming the facts are proven, whether it's quote-unquote mitigating or not?
No. What they did, and interesting, in the 2020 record on appeal, the verdict form is not in there. It is only in there as an exhibit to the motion for new trial, and it starts at page 1319. But it only goes through saying, evidence was presented on this, do you vote yes or no? And then they go through and
Yes or no as to what?
whether or not it's mitigating.
Okay, so in that sense, so really then, I mean, that just shows that supports the idea that maybe the jury, so the inconsistency, it's one thing to sort of disagree as to whether something factually was proven, did someone have a bad childhood or whatever, versus do I consider that mitigating? The jury obviously has discretion, regardless of what facts are put in front of them, whether they view that as mitigating or not, right?
Yes.
And so the form isn't, so it's not as if we can infer from the form that they just literally sort of arbitrarily disregarded the existence of, objective things in reality that happened, as opposed to whatever kind of, sort of judgment-wise, what significance they give to that.
Well, the state maintains that by looking at this form and seeing when the court polled the jury when it gave its recommendation, the jury obviously considered it because some of the jurors, and it was not always the same number.
So the form establishes that they did not ignore the instructions.
Correct.
They may not have considered it in the way that the defense wanted it to be considered, but that's within their province.
Yes, and it shows that they discussed it because some people said yes on this and no on that. And it shows that the jury went through each one individually and discussed it, evaluated it, considered it, and then ultimately weighed them against the aggravators and unanimously found that they did not outweigh the aggravation.
Right, and constitutionally, a defendant, all that you're entitled to is to be able to present what the defendant thinks is mitigating and to have that fairly considered.
Correct.
Right? Okay.
And with that, the court, the state asks you to affirm. Thank you.
Justice Kennedy, I disagree respectfully with you on the issue of whether or not the mitigation was handled properly in this case. The fact they discussed it or did it is immaterial as far as I'm concerned. If they find none existed when it clearly did, they didn't understand what they were supposed to do. That's our position on that. And then secondly...
Well, I think there's some confusion in the way these interrogatories were structured. And
Agreed.
I do not question that, and that ultimately the court decided that, and because we changed it.
Yes, sir.
But the idea, the kind of the premise for your argument is that they really didn't consider mitigation. And that is absolutely contradicted by what we've just been talking about.
Well, I don't want to parse words, but they can consider all they want. We're not claiming they didn't consider it. We're saying they didn't follow the law. That's what he didn't do. The jury didn't follow the law by finding mitigation that existed. That's our position. And then finally, on the second point, The judge was wrong to say that the evidence was easily discoverable. It wasn't. We have a HIPAA law. It was not easily discoverable at the time. And so that, and I'm just addressing the AG's comments in that regard, that isn't true. There was no way they could have known about her medical diagnosis. So it is newly discovered evidence. And with that, I conclude my presentation. Thank you very much.
Good morning. May it please the court, I'm Nancy Ryan representing Timothy Fletcher. This is indeed also a Hurst resentencing, and this is indeed also a case where the issue of the check box was raised in the briefs. If I may, on mature reflection, I am inclined to agree with what Justice Kennedy said, which is that the issue is waived in this case, because the defense counsel was asked by the trial judge, do you have any objection to Part C of the verdict form? And the answer was, there's a typo. So since we agreed to asking the jury, does any of you agree with any of this, yes or no, I have to concede that we are in no position to say, what do you mean that? I also agree with the view expressed that the question is not particularly helpful, and perhaps the jury instruction committee should take a look at that portion of the verdict form. I know the Public Defender Association has a few words to say to that we'd like to say to the jury instruction committee on that. We do see from the record of this case that Judge McGillen was not happy with the jury at first, because he felt justly, I think, that his job had been made much more difficult in that he had to sort out all the mitigation himself. But in the sentencing order, and indeed in the defense sentencing memo, both the defense counsel and the judge came around to the view expressed this morning that, well, maybe they just didn't think any of it was mitigating. Maybe they did think about it all. But I would ask the court to remand, not so much remand as refer this matter to the matter of the checkable box to the jury instruction committee. And having said all that, the checkbox is quite significant in this case because in that the judge found that even given the checkbox, the case was a close call in his mind. That's at record page 4123 in the sentencing order. As I mentioned, this is a Hurst resentencing. This court last saw this case in 2015, and a great deal happened between then and now. Not only after a plenary de novo resentencing do you have a judge who found it a close call, you've got a judge who found the violence was an impulsive reaction to unexpected resistance, and that's also in the sentencing order at record page 4105. The judge said that in the context of giving only little weight to the defendant's age of 25. He said, yes, it's impulsive. The judge said in the order, yes, it's impulsive. The action was impulsive, but that didn't cut much ice with him. Another thing that happened since this court last saw this case is that the state conceded that what happened after the defendant's stories diverged, what actually happened at the scene, is not exactly clear. That's new too. In light of all of that, it's my position that the absence of an Edmund-Tyson instruction amounts to fundamental error in this case. I need to distinguish this case, obviously, from the 21 decision of this court in the Christian Cruz case.
And on that, can you tell us what would be the trigger for requiring an Edmund-Tyson instruction? Is it any time there is substantial participation in a murder of a co-defendant?
I'm so sorry.
It's all right.
I'm so sorry. Well, the jury instruction committee has, in fact, addressed Edmund-Tyson during the course of this appeal. They have issued standard jury instruction number 7.14, which sets out the excuse me, for possibilities that include a defendant in the class of individuals who are eligible for death. Edmund and Tyson are...
So you're suggesting the trigger should just be death eligibility?
It's got to be a felony murder case. It's got to be, there's got to be some dispute over who the actual killer was, I think. I'm pretty sure that that is a sort of floor for Edmund and Tyson to really come into play. And that's very much the situation in this case. On the third day of penalty phase, the judge said on the record that this is a whodunit.
And you're suggesting that it would be fundamental error in any, I mean, I think the way our fundamental error cases work, you'd have to be proposing that it is always error for this not to be given. Like the court retains no discretion to speak to the specific facts of the case. If there's a felony murder and it's death eligible and there's any conceivable dispute about a co-defendant being involved, then the rule you're asking us to adopt is it is always fundamental error to not give an Edmund Tyson.
Well, fundamental error depends on a showing of harm, and I think I've got that in this case, which Mr. Cruz did not. Cruz was the very simplest model of an Edmund Tyson case. There were two defendants, one victim, one gun, one shot fired in the back of the head. Somebody did it, somebody didn't do it. And the jury's guilt phase findings in Cruz established that Cruz was armed. There was, this court would, I think, have been mad to find that not harmless, that the Edmund Tyson instruction was not given. There was only one conceivable outcome. This case is quite different.
How does it figure into this issue that it seems to be undisputed that the defendant here was the mastermind of this, going to his step-grandmother or whatever the relationship was. He's the one who knew her. He's the one who didn't like her. And he's the one that thought she had money. And that's why they went there. And there's no question about that, is there?
There is not. He did plan the robbery. But again, you've got the judge finding that the violence was impulsive, was not in fact planned. And I'm relying on this court.
I'm sorry to interrupt you, but whether it was, regardless of the extent to which it was impulsive, there's no dispute that both of the men were very much involved with physically.
They both had hands on her.
Right. And so are you saying that for this Edmund Tyson thing that there's no element of, there's no sort of threshold requirement of kind of relatively minor participation that has to be established, or at least, you know, possibly there before this comes into play? I mean, when two people are sort of equally involved with this, it just doesn't seem like this issue really even comes into play. Is that wrong?
Well, if I'm understanding the question correctly, the Tyson case clarifies Edmund and says that at a minimum, to be eligible for the death penalty, the defendant has to be a major participant in the underlying felony and has to have exhibited reckless indifference to human life. And I imagine the question's about to arise.
But on the facts we've got here, I don't see how you can get over that threshold.
Well, the answer to that question, Your Honor, a major participant, I think the state has a lock on that, in that he did plan the robbery and get them there. It's the intent element.
And at least when he's got hands on her and is doing all this stuff and is angry, and the idea that is doesn't meet that other prong of at least reckless indifference.
Well, I'm not so sure
I think you could look at this and say there's much more than that, but I don't see how this even falls in the universe of that case. I mean, I'm just following up what the Chief has said. The facts here just don't seem to fit what those cases were talking about.
What we do know is that the jury was very particular about standards of review in that they did check the box no for mitigation. They didn't find anything met the preponderance burden, 51%. They may well have had a problem with the fact that under Edmund and Tyson, the state has to prove beyond a reasonable doubt both prongs, both major participation, that's a lock, and reckless indifference. I'm just not sure what a jury would have made of that, because indifference to human life is, to me, a very tremendously culpable mental state. It means he didn't care at all, either way, if she lived or died. But reckless indifference is clearly something more, and I think a rational jury could have some trouble with that in a case where the state waived death as to one. And it is a closer case now than it was in 2015 when the court last saw it. For the reasons I said earlier, the impulsive reaction finding, that's new. And the state conceding that it's not exactly clear what happened after the defendant's stories diverged. So I submit there is a live issue here, and I'm relying on this court's line of cases culminating in Perez versus State from 2005, where Perez sort of fills the role of Apprendi in this case, in this context, in that this court, up to and including in 2005 in Perez, required not only an instruction but findings from the jury, and the jury instruction committee clearly in 2023 is under the impression that that is still the law. I hope the court is not considering receding from Perez versus State in light of Cruz 2. I'd submit that would be a mistake, because in Cruz 2, when that was the case we were talking about before with the one shot. And it went back because our Judge Zambrano down in the 7th tried both cases separately, and he had both records in front of him when he wrote his sentencing order. And this court said, well, you can't rely on both. You got to rely just on what was introduced against Mr. Cruz. And so the case went back. The judge said, actually, yes, I did mean death for Cruz and life for Mr. Charles, the co-defendant. And on appeal in 2023, the defendant argued, well, you have to give me life because my co-defendant got life from the same judge, and there's not that much to choose between us. And this court said no, for two reasons. First, there's a lot to choose between the person who put a bullet in the back of someone's head and someone who was standing by. And the second reason is, I'm sorry, I lost my train of thought. I'm sorry, Your Honor. Oh, yes. This court, of course, invoked Lawrence at that point and said, we're not in the business of cutting death sentences down to life sentences because someone else got a life sentence. We're not doing it in any context. That's not what's being asked here. Emmett and Tyson create a categorical exclusion from the death penalty. This is not a mitigation case. This is not an aggravation case. It's very much a third thing. And I think that given the prominence of the jury's role in Florida's system, that this court should stick with Perez, because it should go to the jury to determine these difficult issues, which may very well be dispositive in a death case.
On the issue of fundamental versus harmless error, what does the fact that the jury knows of the life sentence for Brown weigh in? In other words, couldn't they have essentially considered what they would in the context of this instruction and reach the same conclusion?
Your Honor, we did get all the mitigation we wanted. I apologize. I'm not sure I heard the question.
Sorry, the jury knew of Brown's life sentence, correct? And mitigation?
Yes, the judgment and sentence over the state's objection came into evidence and were argued as mitigator number one.
So why doesn't that essentially create the context that the jury needs to reach the same conclusion, or to make the same consideration they would if the instruction that you're advocating for had been given?
Because Emmett and Tyson are just a whole different third thing from mitigation. We got all the mitigation we wanted. We argued hard for it and got it. That may be how it came about that nobody thought to ask for an Emmett and Tyson instruction. I don't know how that happened. I called up trial counsel and asked him, and he didn't remember offhand. I imagine the post-conviction folks will refresh his memory. But no, I don't think that substitutes, because they needed to, because under Emmett and Tyson and Perez, they have to find beyond a reasonable doubt that the defendant is in the universe.
But going back to what Justice Sasso was saying, I mean, not only was the jury aware of the fact that co-defendant, what was his name, Wells? Brown got a life sentence in a plea deal. They were given the actual plea paperwork to look at, and I'm sure the prosecutor was screaming and objecting. But the jury was also told to consider the co-defendant's life sentence as a mitigator.
By counsel, yes.
They were told that, but so I mean, so the jury was aware of it, They were told to consider it by counsel as a mitigator, and yet they, given the facts of this case, they chose not to do that. That's not what juries are supposed to do, weigh the evidence and decide.
Judge, I'm going to rely on Boyd versus California, where the U.S. Supreme Court held that the argument of counsel is just not given the same attention or obedience by a jury as what the court says.
Yeah, but you know, like you argued earlier that this, that Mr. Fletcher's actions here were impulsive. But my understanding of what I read is that this whole crime, what this poor lady went through, it took a while. It wasn't just a real quick thing. I mean, they beat her, they strangled her. At the end, I think one of them put a bag over her head, and then the other, and then Mr. Fletcher tried strangling her with a cord. I mean, it wasn't a sudden, impulsive thing. This went on for quite some time.
You do have a finding from the trial judge who heard the confession and heard the medical examiner's evidence, and he found it was impulsive. And then the judge did find, Judge McGillen did find that, I'm sorry, I've lost my train of thought again. Let me just say, Judge McGillen is greatly respected in my part of the world. I have sat in on a 3-day trial in his courtroom, and I think he is the person you would want deciding this life or death matter. And I think that he would have given this instruction if he'd been asked. I think he was or is probably beside himself that he lost the opportunity to ask the jury again what they thought about relative culpability. On that note, I will tend to the case. Thank you.
Thank you.
Good morning. May it please the court. My name is Doris Meacham, and I'm here on behalf of the state. I'd like to start with addressing the point that the state never conceded that it was unknown what happened after their stories diverged. The state argued that Mr. Fletcher was indeed the one who strangled and killed the victim. That was never conceded, that we didn't know who did it. It wasn't a whodunit. It was very clear that it was Mr. Fletcher. The evidence in the case pointed to Mr. Fletcher being the one who killed the victim. One of the things that was brought out during trial were the scratch marks that were on Mr. Fletcher's arms, the DNA that was found under the victim's nails that matched his DNA. This was not a whodunit. Based on that, I don't believe that Edmund Tyson even applies to this case. And I know that defense counsel argued that in Cruz, the jury made special findings on the verdict form that Cruz possessed a firearm and discharged the firearm causing the death of the victim, and that's not found here. However, in Cruz, this court found that there was no competent substantial evidence in the record to support that finding. And after that, this court went through the evidence and found that there was sufficient evidence to find that Cruz was responsible for the death and entitled to the verdict of first-degree murder.
There was no similar DNA evidence found on Brown's person?
Brown had no injuries whatsoever on his person. And in fact, when they first interviewed Mr. Fletcher, his story was that he really didn't have anything to do with it. It was Brown, he was there. And once the police came back with evidence that they had DNA, that's when he started to change his story and say, yeah, I got these scratch marks, but it was just from holding her down. But no, there was no evidence of any DNA from Mr. Brown found on the victim. And again, if you want to look at whether or not he was a major participant, Fletcher's the one, the mastermind behind all of this. He's the one that stole the tire iron. He's the one that came up with the idea to break out of prison because he was just sentenced to a 10-year prison sentence, and he was not going to serve that. He's the one that pried the toilet up. He's the one that had the plan to go to the victim's home because he knew she had a safe and had money. It was his idea to go there. He knew how to get into the house. He's the one who tortured this woman. It wasn't impulsive. It wasn't quick. She did not want to give the number to the safe. She did not want it to open up because she had no money in there. She kept telling them that. They chased her around the house. She went into the bathroom and locked herself in the bathroom to get away from them, and they managed to get her out. She finally opened the safe, and there was no money in there, as she had told them. This was not impulsive. This was not quick. This was thought out. He hated her. There was evidence of that. And when he found out there was no money and she was useless to him, he got rid of her. As far as the jury not finding any mitigation in this case, it's quite obvious that they did not feel that it was mitigating in comparison to what was found in this case. The judge himself, in doing his sentencing order, did find mitigation, but made a note of that there was no nexus between what the mitigator was and the reason for the murder. And I believe that that's what the jury did in this case as well. They considered all of the evidence, and they did not find it mitigating in comparison to what occurred in this case. And that is what they are entitled to do. What Lockett stands for is that a defendant cannot be prevented from telling the jury about any relevant mitigating evidence. That's what Lockett is for. That's not what happened here. They were permitted to present everything they wanted, including the life sentence. What the jury has to do is to listen to it. They don't have to accept it. They don't have to believe it. And in this case, they did not. And if there are no further questions, the state would ask that you affirm Mr. Fletcher's death sentence. Thank you.
Thank you.
Your Honor, the state did, counsel for the state did say in penalty phase closing that it is not exactly clear what happened after the story started to diverge. That's at transcript page 1036. And it's the judge who called it a whodunit at transcript page 607. I submit to you that scratch marks are getting too much importance. This was quite the scene, as we've been saying, as Mrs. Meacham's argument makes clear. It's the fact that the victim got a couple of fingernails on one person's arm. I just don't see how that logically establishes that he's the one choking the life out of her. They both admitted they had hands on her. And once again, it is the judge's finding that the violence was impulsive rather than the robbery. Right, that's at record page 4105 in the sentencing order again. And with that, I ask the court to reverse for a new penalty phase where the advertising instruction can begin.
Thank you very much. The court will be in recess for 10 minutes.
All
Leave it up there. Leave it up there.
The Supreme Court of Florida is now in session. Please be seated.
Our third and final case for today is State of Florida versus Kaczmar and Kaczmar versus Dixon, numbers 22, 16, 71, and 23, 725. Thank you.
Mr. Chief Justice, and may it please the Court. My name is Jason Rodriguez, Assistant Attorney General for the State of Florida. In my time before the Court, I'll explain why this Court should reverse the grant of a third penalty phase to Mr. Kaczmar. The lower court granted him a third penalty phase after determining that he received ineffective assistance of counsel because his counsel at the outset of jury selection failed to object when the resentencing court told the prospective jurors that Kaczmar was previously sentenced to life - death. The State of Florida's appeal exclusively challenges the deficient performance rule, or I apologize, the no prejudice ruling. The court below found that
was just a dash.
Right. Yeah, exactly. Exclusively challenges the prejudice prong of Strickland.
And so at this point, you're just conceding that it was deficient performance.
We haven't appealed that, so we've waived any challenge to that, correct, at this point. Not saying that it's not an argument that could have been made, but we decided to focus on the no prejudice ruling because it's so straightforward and simple for this court to do, so there wasn't need to delve into deficiency.
Let me ask you this. It's in, because having been a trial judge for a long time, this is the things that come up all the time, and sometimes judges misspeak, you know, say things they shouldn't say because it just slips. Well, what if, let me change the facts a little bit. What if we had remanded the case back instead of for a new penalty phase, remanded back for a new trial on guilt, do the whole thing all over again? And the following instruction was given to the jury. I take it what happened was they brought in the big panel, and the judge takes the bench, and he's trying to explain to the big panel why we're here. So let's say that the instructions, or the preliminary instructions the judge gives, was something like this. I wrote it down because I wanted to do it just right. Let me see if I can find it. Okay. The trial judges in making, he says, this case, the judge says, this case has a little history to it. So let me explain your duty today. The defendant was found guilty of murder in the first degree on 8/12/10. However, the Florida Supreme Court sent the case back here with instructions that the defendant is to have a new trial on the question of whether he's guilty or not. Okay? Would you not consider that to be prejudicial, that the jury is told that he had previously been found guilty?
So under Strickland's prejudice prong, actually, no. Now, I think on direct appeal, counsel can certainly object and certainly make an argument, but we're dealing with a very interesting arena. We're no longer on direct appeal. We're no longer at trial. Instead, we're trying to figure out what is the reasonable harm that the defendant suffered in front of an objectively reasonable jury following the law. In your hypothetical, I assume that that jury later on is instructed, you must focus only on the evidence that is before you in this trial.
Yeah, but you know what? I mean, I read that, and I read those instructions to at least God knows how many juries. And you tell them you got to follow the law. If he failed to follow the law, it will be a miscarriage of justice. You must rely only on the evidence. I mean, and we're supposed to pretend that jurors are like computers. They only answer and deal with what you plug in and plug out. These are people. And telling someone that, okay, you're about to sit on this murder case, and you got to decide whether, going back to my example, he's guilty or not. And then telling them, oh, by the way, he's been previously found guilty by another jury. I mean, that seems to be like the sacred cow of the judicial system. Now, we do everything possible for a jury not to hear something like that. How is that with dealing with human beings sitting on a jury, and just because we tell them disregard anything that I tell you to disregard, follow only the law, if we go that way, then prosecutors can say whatever they want. And then later on, you know, when the jury hears the instruction, they disregard that, just follow what I tell you. We're supposed to pretend that that happens. So if we do it your way, then anyone can do whatever they want at trial.
So, Your Honor, I disagree. I think especially in this case, we're talking about when's the right time to raise it. I even conceded to you, defense counsel can raise it at trial. We can have a discussion about whether that's harmless error or not on direct appeal. The question, though, for this court now is, are we going to let you reach back in post-conviction and get to that same error? And the United States Supreme Court, I think, has given us the answer to that question, and it's no. I'm going to quote from Strickland itself. 40 years ago, the Supreme Court crafted the prejudice prong we still use today. In making the determination whether specified errors resulted in prejudice, a court should presume, absent circumstances not relevant here, that a judge or jury acted according to law. An assessment of prejudice of likelihood of a result more favorable must exclude the possibility of arbitrariness, whimsy, caprice, nullification, and the like. Moving forward, it must proceed on the assumption the decision maker reasonably, conscientiously, and impartially applied the standards governing the decision.
Counsel, can you kind of focus on what you think are the strongest arguments that there's no prejudice here, based on the facts of this specific case?
So, Your Honor, I think the strongest and easiest is the presumption that juries follow the law.
They were given the instructions. This was a brief comment at the beginning,
right.
Correct? What else?
So we did raise two other arguments. The other arguments are that there's no prejudice given the minor nature of the mention. You know, as Justice Grosshans, you just mentioned, it was a pre-jury selection comment. It was never repeated. The jury was given the correct instructions. So there's a minor nature of the comment, and under Tefteller versus State, where significantly more mentions of a prior death sentence
I
were
think
given.
maybe we've lost the thread a little bit, though. Like, one clear distinction between this case and the hypothetical that Justice Labarga proposed to you was that we're here on Strickland. We're here on ineffective assistance of counsel. We're not questioning on a direct appeal whether, for example, there should have been a motion for a mistrial. That's not what's before us. We're talking about what kind of job did the lawyer do, and does it amount to a total deprivation of counsel under the Sixth Amendment? Why aren't you leaning more into that? It seems like that's really your best argument, isn't it?
Well, Your Honor, I think that goes with the presumption that juries follow the law. The reason that we have that presumption is because we are trying to isolate and figure out what is the reasonable harm that he suffered in the face of an objectively reasonable jury. And the reason that we focus on what does the objectively reasonable jury do is because we're only focusing on counsel. These aren't juror misconduct claims. These aren't judge misconduct claims. We're trying to figure out, okay, counsel made an error. We haven't challenged deficient performance. What is the reasonable impact of that error? And so I think the arguments end up going hand in hand. We're focusing on the presumption juries follow the law because that's where it comes to the fore in this case.
Should we consider the weight of the other factors here? The weight of the evidence against him, the weight of what they would have been looking at to decide on the death penalty. Should we look at that in comparison to what impact the statement might have had on them?
So, Your Honor, yes, and that was, I believe, the state's third argument is let's just look at aggravation and mitigation. This would have made no difference. The reason that I think it's kind of critical to really get back to Strickland and what it says about how the prejudice prong is to be applied for an ineffective assistance of counsel claims is because, as the Supreme Court said in Weaver versus Massachusetts, these kinds of claims, ineffective assistance of counsel claims, allow defendants to escape the rules of waiver, forfeiture, any number of things. This Court heard several arguments today about how, well, this is just going to come back in post-conviction. And
well, you know, if we went down the road that they're suggesting, it seems to create kind of a perverse incentive for counsel. You see some little problem, which you might put this in that category. You may actually like the jury pool that you've got and think, I don't like this jury pool. He shouldn't have said that, but you know, I'll keep that in my pocket, and that'll be down there for post-conviction, and so there's something there that I'm not going to object to. I just think the whole thing it can turn a molehill into a mountain, and it allows gaming the system.
And, Your Honor, I think there's that concern. I think that's why these presumptions help us prevent some of those games. When we apply Strickland's prejudice prong correctly, it gets rid of a lot of the chaff at ineffective assistance of counsel claims. It focuses us on the things that really matter. What was the aggravation and mitigation in the case for a penalty?
But I think, you know, Justice Kennedy makes a good point. I think it probably goes to deficiency, which is why I think you've heard from a couple of us a question about why you waived deficiency. Like, is there no universe where the defense counsel here made a tactical choice? The judge misspoke. I'm not going to object because I do like the jury pool, or because he immediately corrected himself. It was a stutter. It's not a big deal. Why aren't we engaging on that issue?
So I could give you the reasons that I didn't brief that issue. One, counsel didn't actually say that's why I didn't object. Counsel said, I didn't understand that as telling him to death. So my facts were not as strong. So
counsel's, I'm sorry, can you go over that again? Counsel's explanation was he or she was caught unawares?
I didn't understand that as him telling the jury that he was previously sentenced to death.
Got it.
Now, Strickland's objective, so I still could have made the argument, but I really think the prejudice prong is the way to shave a lot of these other issues.
I got it. Okay.
Well, wait a minute. I think that the record showed that the counsel for the defendant testified that the judge kind of mumbled and they did not hear it or understand it. And then they called the court reporter to testify. And, you know, as you know, in courtrooms, the court reporters sit usually right down there. And defense counsel, depending on the size of the courtroom, is sitting like where you are. So the court reporter is in a much better position to hear. And she basically testified that this particular judge sometimes mumbles and stumbles over words. And so she's used to that, and she catches it. But the defense counsels testified that, I mean, it was not their understanding that that's what he said.
Right. And the prosecutor
Otherwise,
as
they
well.
would have stood up and objected. And now, of course, that could work right into Justice Kennedy's suggestion. They may be gaming the system, pretending they didn't hear it, and saying those things. But that's the testimony here. So the judge just ad-libbed this, and she would follow the instructions we gave him in Hitchcock to do, and he didn't. And that would have cured everything. But that's what the records show.
Correct. And so that's why, you know, Strickland's objective, could I have argued Division 4? Certainly. But I think the reason the state focused on the prejudice prong here is because, to get us back to that, jurors follow the law. And when we're trying to figure out what's the impact, we've got to do this analysis, the analytical framework, in order for it to function and work. We can't just be trying to figure out what was going on in Juror 5's head. We have to do it on the objectively reasonable juror. And in this case, the objectively reasonable juror was told how to conduct the analysis and how to do so correctly. And if the jury, following the law, as Strickland requires us to presume they did, came to the conclusion that they did, this pre-jury selection comment would have had absolutely no impact. So I think the reason the state's focused on the prejudice prong is because it has such broad application to weed out, to focus on what matters in a Strickland claim as opposed to what does not. I'll note the United States Supreme Court in Strickland. I apologize.
I was just going to say, I'm sorry to interrupt you, but there's a lot of issues you're going to have to respond to, and you're well into your second 15 minutes. So, but it's up to you.
About to conclude, Your Honor. The United States Supreme Court said in Strickland that one of the things they were concerned about was that you'd have a trial of guilt followed by a trial of counsel's effectiveness. And they gave us this prejudice prong, in part, to focus on what matters and to weed out all the rest. There is a lot of chaff that gets raised. And this prejudice prong, the correct analysis, what the Supreme Court gave us in Strickland, is one way to focus us on what's wheat and what's chaff. With that, I'll reserve the remainder of my time for rebuttal.
Thanks. And we can put it back at 10 when he comes back, and you guys can have more time as well. Thanks.
May it please the court. I'm Elizabeth Spiaggi for the appellee, in this case, Mr. Kaczmar. Firstly, I'll respond to the state's appeal. And secondly, if time permitting, I would like to address the first claim from our habeas petition regarding ineffective assistance of appellate counsel for not raising the failure to hold a Nelson hearing. This court previously, on direct appeal, granted the new sentencing because you vacated Mr. Kaczmar's contemporaneous conviction and found that many of those aggravators were not supported. It was sent back, as the state presented, the penalty phase judge instructed the jury at the outset of jury instructions that he'd previously been sentenced to death and that they were here for another penalty phase.
Counsel, can you kind of focus specifically on the prejudice, since
Absolutely.
the state has conceded that there could have been an issue with performance? Can you kind of tell us where you think, and where you've kind of pointed in the brief to what the prejudice is here?
So I think I would rely on the lower court's order, where he found that this was an inherently biased jury. He pointed.
And what would we base that on in our law?
So at the onset, they're told about this sentence of death, and they're told about it in the context of jury instructions, right? This is different from the cases that the state cited to Teffelteller and Lowe, where this came in as evidence through a witness, right? And I think that's the problem with the state's argument, right, presuming that the instructions cured this. The instructions did not cure this because the instructions tell you only to consider the evidence that's presented at this proceeding. But I don't think they understood this as evidence, right? The judge tells it to them and then explains to them what their role is in resentencing, and then later asks, does everyone understand? I mean, that sounds to me like instructions, like jury instructions. So I don't think the jury would have had any idea that this was something they were supposed to disregard. And honestly, I think it's almost worse that it wasn't addressed again, right? The trial attorney could have interceded and they could have done a better explanation to the jury. As it stands, the jury's only...
So the inference here is that because the jury heard that, they're going to conclude, even though we know that that decision was overturned, it was determined to be legally incorrect, that because we know that, we're going to be inclined to do what was determined to be legally incorrect previously. I just don't understand the logic of that if you are assuming that they're going to follow the instructions they're subsequently given. I don't get that.
I think since it happens at the very beginning, and every juror that was selected was in the panel that heard this comment, since it's done at the very beginning, every bit of evidence that they're hearing is coming through this lens, and there's sort of going to be some confirmation bias.
But the lens involves them being instructed that that was determined to be legally incorrect.
That I don't think that they understood.
Well, I mean, now we get into speculation.
Now we are getting
into speculation, and you're assuming the worst. And I think that under Strickland, which opposing counsel I think is very skillfully focused on that, I think under that we don't assume the worst. Like, to the contrary.
I don't understand how the jury's receipt of this information could in any way benefit Mr. Kaczmar, right? It's only detrimental to him.
Right, but it has to be detrimental to the point that we find he was deprived of his right of counsel to such an effect that, you know, that the jury would have ignored everything. They, you know, first of all, we don't even know that they heard this comment because neither attorney seemed to that was sitting there. It was a brief mumble in the first couple of sentences, correct, of the sort of introduction by the judge. We don't know. We would have to assume that they ignored all the aggravators, everything that they heard, and they focused solely on this to such an extent that they then ignored every other instruction they were given to reach the conclusion they did based on this one comment.
I think I disagree that they have to ignore the other instructions in order to consider this, right? I understand that logic in Tefateller and Lowe, where it's coming in through a witness, so clearly it's evidence, and in Tefateller, I think the prosecutor further addresses it and tells them, you've been told he had a prior death sentence, that's not to affect your decision. I think even some sort of curative instruction to that extent would have been helpful. And let's also remember that the judge didn't give any of the traditional preliminary instructions about you can't consult with electronics, you can't use outside information, you shouldn't do your own investigating. He didn't even tell them that they're not to form a fixed opinion before the end of the presentation. So I think all of that together, they're told very little at the outset. They are told this.
So at the beginning of the trial, beginning of the proceedings, when this occurred, let's assuming that counsel heard it and stood up and says, I object, Your Honor, that obviously we do it at the bench, and I'm moving that you strike this entire panel and set up a new panel. Is that what would have been, what should have been done?
I think that would have cured it, and it would have been a quick fix.
Well, yeah, but that's not really the question before us. The question is that the only thing competent counsel could have done?
As far as that standard, I mean, it doesn't have to be a complete abandonment of counsel. It's what a reasonable attorney would do. And I think Mr. Shea even, and Mr. Anderson confirmed that if they had heard that, they would have objected because they do think it's prejudicial, right? I think that's that is the standard of what counsel would have done, and it didn't happen. I don't, and the lower court didn't put a lot of stock in the credibility determinations of their testimony that it didn't happen. I think it's possible they didn't hear it, right? We trust the judge to present the jury instructions. It's not a particular point that they might have been paying a lot of attention to. Additionally, it's important to remember how this penalty phase proceeded. There was one live witness, and otherwise trial counsel and the state are reenacting the previous penalty phase by reading the transcript. So this jury is painfully and acutely aware that this is a redo, right, as they've been told and as they've been told that he was sentenced to death. So I think that's going to be constantly in their mind as they're hearing and evaluating.
And did that occur on the stipulation of counsel? Was there any objection, I can't recall, from defense counsel to that manner of presentation, a cold read of the prior?
No, and in fact, I think it was partially Mr. Kaczmar's choice in waiving mitigation and I'm not taking fault with it as an ineffective issue.
But doesn't the fact that that played out that way actually undermine your point that you're raising here? Because it's like the jury's going to reasonably infer that anyway based on the way it's presented to them.
Well, I think what's an important distinction is that he didn't waive a jury, right? He wasn't okay with just being sentenced by the judge. He still wanted a jury to be the one determining his sentence, right? So for that reason, and because a jury can hear aggravation that outweighs mitigation and still vote for life, I think it's very problematic. To Justice Labarga, to your analogy, where if someone was told that the defendant is guilty, sort of how would that play out if it was a retrial? There is a case to that point, which I only discovered in researching the state supplemental authority, and that's Arthur v. Bordenkircher, where they found it's a case. It's from the federal 3rd district, and it's a case of ineffective assistance of counsel, where counsel.
Have you filed that?
Pardon me?
Have you filed that case?
I have not, because it's not.
Well, I don't think you ought to talk about it unless you presented it to us in opposing counsel. You can do it subsequently.
Okay, I'll do it subsequently. I didn't know if it was proper to file a supplemental authority with it not being a new case, but it was something I found in response to his supplemental
Well, if you're going to talk about it, I think we need to know about it.
Okay. Can I talk about it and then file on it?
No. I think that's the way it's supposed to roll.
I mean, I think it would certainly help your analysis. Ultimately, too, I think part of the prejudice analysis has to factor in that he has a right to an impartial jury, and that's what the lower court cited as being the violation, right? This is a fundamental error, and so we also raised it in the habeas.
And have we ever found this to be a fundamental error?
We've never been presented with this situation where
So why do you think this is a fundamental error?
Where it's coming from the bench? Because it's, as the jury is being presented as part of their jury instructions, which they're supposed to follow, they're being told that the defendant was previously sentenced to death.
So your argument is that there's no way the jury could have found death in this case but for this comment, because that's fundamental error.
I think that it's because it affects the structure under which the proceeding went. There's really no way to parse out how the prejudice affected it. We just have to accept that it's prejudicial to have a biased jury. I think I've covered all the points I'd like to relating to that. I'll move on to the habeas claim of ineffective assistance of appellate counsel for failure to raise the Nelson hearing. Mr. Kaczmar wrote a letter to the court stating that he thought his counsel was unqualified. He had met with counsel 2 times in 10 months, and he wasn't happy with the communications. Counsel wasn't filing motions. He wasn't investigating. And nothing ever came of this. And I think it's important because a Nelson hearing implicates so many other rights that would be possibly extended to him, right? He would be explained that he could represent himself, he could retain someone else. The other thing that happens at a Nelson hearing is a lot of times the judge will reassure the defendant about the qualifications of counsel, and maybe will make comments to counsel that you need to do better in communicating with your clients.
Was this issue preserved in the lower court?
Again, I would say that Mr. Kaczmar's letter raises the issue, and that it's fundamental error not to hold a Nelson hearing, not to hold any kind of Nelson hearing, and that's the case that I cited to in the briefing. I would rely on those. Those are DCA cases.
That sounded like a really long no.
Oh, as to, maybe let's repeat the question.
Okay. Was it preserved below? That seems like a yes or no.
I think that Mr. Kaczmar preserved it.
There was no objection by defense counsel. It wasn't brought up before the judge that they should hold a Nelson hearing, correct?
I mean, I don't know how you can expect.
Was there a ruling?
There was no ruling.
Okay.
It was never addressed. I don't know how you can expect incompetent counsel to preserve errors raised by the defendant, and it's prejudicial to Mr. Kaczmar, but he doesn't know that he doesn't know the rules of preservation of the claims.
Isn't your argument, and I'm sorry if I'm wrong, but
yeah,
isn't your argument that appellate counsel was ineffective for not arguing that it was fundamental error?
Yes.
Okay. So it wouldn't need to be preserved.
Right.
Right.
I mean, but
this is about the deficiency of appellate counsel in failing to make an argument about fundamental error. Now, that's not, whether that's got any merit to it, that's a different question, but that's what you're arguing.
Yes. And I think that this court has found when there is a Nelson hearing, it's not fundamental error for the Nelson hearing to be inadequate, but I think for this issue not to have been addressed in any way changes the way this proceeding proceeds, right? So in that way, it is a structural error that affects everything that happens after that at trial. I think the next issue I'd like to address was the ineffective assistance of trial counsel. This is I think the first claim in our brief of counsel not objecting to the detective vouching for the credibility of really the state's star witness, this jailhouse informant, Mr. Valencia. Am I into my rebuttal time?
No, we'll add 4 minutes, just like we did for the other side.
Okay. And as far as that, it seems that the lower court did sort of presume deficiency on that, but ultimately concluded that it wasn't prejudicial, and then they sort of outlined a lot of the evidence that was introduced at trial, which I think based on our evidentiary hearing and the recording introduced by the state at the evidentiary hearing, some of that undermines the original evidence at trial. One of the things that the court pointed to in finding that it wasn't prejudicial was that Mr. Kaczmar was the last person with the victim. Well, Mr. Mosley was also one of the last people to see the victim, and he also pointed to neighbors hearing Mr. Kaczmar argue with a man in the backyard shortly before the fire, and I think that plausibly also that's Mr. Mosley who he's arguing with, and that's exactly what came out at the evidence that's what comes from the recording the state introduced, that Mr. Mosley was the perpetrator of this crime, and Mr. Kaczmar was in his room in some sort of drug-induced stupor, and he did assist Mr. Mosley by purchasing the gas, so that piece of evidence is no longer really incriminating, and also the victim's DNA on the socks. I mean, in the recording, Mr. Kaczmar admits to being on the scene, so presumably he would have had the victim's DNA on him, and all of these are.
So just to make sure, I just want to make sure I'm following. So the argument is that the vouching by the detective for this witness was so prejudicial because there was not overwhelming evidence of guilt otherwise.
There was not overwhelming evidence of guilt, and there was also a lot of other impeachment that we brought up, a lot of other instances of ineffective assistance of counsel that undermines this jailhouse informant's testimony. So I think that together, all of those things with Mr. Valencia are problematic. There's also the introduction of the testimony about the polygraph, right? That how shall I set this up? Counsel had deposed Mr. Valencia, the jailhouse informant, and then and in that deposition, he asked him. He said, "Why were you so sure that Mosley was innocent?" He said, "Oh, Kaczmar told me that Mosley took a lie detector test." And then Mr. Shea at trial asks that exact same question, gets the exact same response, and that's after having filed a motion in limine to exclude all this evidence, to exclude any mention of the polygraph. Now, the lower court, in their decision, in their reasoning, said, well, it was reasonable for Mr. Shea to presume that the state would have instructed him. Okay, well, then that seems like a problem on the state. That seems like the lower court's actually undermining the ruling at trial, where the court said, it's not the state's fault, you asked the question, you know? So I think those two things, that sort of contradicts what we would normally rely on as the competent substantial evidence to defer to the lower court's ruling. Then there's the issue of, the other thing that came in was this whole scheme that Mr. Valencia sort of set up for Mr. Kaczmar when Mr. Kaczmar was dissatisfied with Mr. Shea's work, and he was really getting sort of desperate and concerned that they're gonna find me guilty of this crime that I'm innocent of. And Mr. Valencia convinced him that I have this guy on the outside who can do favors for you and can help investigate and refocus attention onto Mr. Mosley. And Mr. Kaczmar went along with that, but the recordings that are introduced are all very incriminating, right, where he's talking to this guy about planting evidence on Mr. Mosley. But I think it's less evidence of consciousness of guilt, and it's more just evidence of Mr. Kaczmar's complete desperation. And that was in the recordings, too. He said, I'm innocent, I don't think my attorney's doing the right thing about this, so that's why I'm doing all of this. And Shea attempted to get some of those statements in, and the state objected and said his felonies have to come in. At the evidentiary hearing, Mr. Shea did not present a really coherent strategy as to that. He talked about character evidence, he talked about a lot of things, and ultimately the court relied on, well, he didn't want them to hear that he was a felon. That's reasonable. And I would agree that that could be a reasonable strategy, except that Mr. Shea agreed to all this evidence about Mr. Kaczmar using drugs. So I don't understand the distinction between hearing that, you know, he's a convicted felon and that he's a cocaine user, right? It just, to me, it doesn't promote a lot of reliability in the reasoning cited by the court. And that was really all the state had as far as evidence, was this one guy, Valencia, who had the whole story, and then also the other things set up by Mr. Valencia, this issue with the undercover detective that trial counsel had no strategy for dealing with other than attempting to introduce the exculpatory statements and then not really reconsidering, isn't it worth it? I mean, shouldn't they hear him professing his innocence? Isn't that more important than maybe hearing that he's a convicted felon?
But arguably, that's a strategic decision that the attorney made and said that he made.
And as I said, I would agree that that's a sound strategy if he weren't already introducing prejudicial information, right? It sounds more like an ad hoc rationalization at the evidentiary hearing, especially since that wasn't initially how he tried to explain it. He really harped on about, well, it would open the door to character evidence, which is not how that works. If I could reserve the remaining time to go to my rebuttal.
Okay, you can have 5 minutes for rebuttal.
Okay.
And I'll get to the habeas issue probably last, but I want to demonstrate maybe why the state's focused on prejudice for issue 1. For issue 2, the issue of Detective Sharman vouching for Valencia, the jury was told it's up to you to determine who's credible and who's not. For the issue about Maudlin's innocence and the lie detector stuff, the jury was given a specific curative instruction. You are not to consider that in any way. The only issue where there was evidence that the state has not raised a deficient performance argument on was, aside from issue 1, obviously, the state's appeal, it was issue 7, where state said, made a note about deficient performance, looks like this probably was suppressible. There's no prejudice based on the overwhelming evidence of guilt. But 2 of the issues that Kaczmar has elected to talk about at oral argument, aside from the state's cross appeal, are easily dispensed with based on what the United States Supreme Court said in Strickland versus Washington 40 years ago. In performing the prejudice analysis, we focus on what would a jury following the law have done with this evidence they presented with. And if the answer is nothing, then there is no prejudice as a matter of law. And we can sift through and pass all of these to the side and focus to the issues that really matter. So, moving us back to issue 1, I do think, Justice Kennedy, you pointed out, the jury was told the sentence was vacated. That kind of gets us to the Romano versus Oklahoma situation where the United States Supreme Court, different context, due process, said information this guy had a prior death sentence could have swayed the jury either way. It just depends on your intuition. That's the problem.
Counsel, the counsel for Mr. Kaczmar has defined what the judge did as part of the instructions to the jury. Do you agree with that? Do you think that kind of every time the judge is speaking that we should consider that instructional? Or do you think this sort of part of the judge's discussion with the jury is something other than instruction?
No, I affirmatively disagree. And I would actually look more to the final instructions that they're given, and I'll quote from them. Let me get to the exact part. Resentencing record at page 165. You must follow the law as it is set out in these instructions, or your recommendation will be a miscarriage of justice. The jury was told multiple times the law that they're going to be instructed on is the law in the final instructions. The stuff that the judge may have said throughout the course of trial, offhand comments, those are not necessarily instructional in nature. The instructions that matter, as far as telling the jury what's the law that you're bound by, are those given in the final instructions, not the ones that are just presented, or just not the statements that a judge generally makes. So I think it's critical, and the other clarification point, the state raised 3 alternative arguments, and I do think there are true alternative arguments on issue 1. The first is that just based on the presumption that the jury followed the law, there's no prejudice as a matter of law. That argument is a standalone argument, and that's really the one that the state would urge this court to adopt straightforward because of its broad application. The second argument that the state made was there's no prejudice just because this was a minor comment. That also is an alternative argument, can stand on its own. This is just an offhand comment pre-jury selection. So there's no prejudice from that. And then the final argument is the Thornell versus Jones argument, which I did supplement for this court, which is we are looking, when we're doing a Strickland prejudice analysis exclusively for penalty phase purposes, at aggravation and mitigation. Here we had extensive aggravation and basically no mitigation because Kaczmar wanted a death sentence and refused life offers from the state. So on any 3 of those, this court could reverse. The state would urge this court to do so on the first alternative at least.
But you can't really separate that issue from the details of how the statement was made, whether it was repeated. Because, I mean, otherwise you end up in what Justice Lobargo was talking about, where if you're just going to sort of let the presumption of following the instructions kind of override anything that might have happened before that, then it really would be kind of open season.
I think that is what Strickland does. We are going to just apply that presumption. That's what that whole paragraph at Strickland tells us.
It's a presumption, meaning rebuttal. It's rebuttable, right? I mean,
so
it's just, I mean, it's academic, but I don't think it would be wise to just hang your hat completely on that.
Well,
and ignore all the, all the other things that put this comment in context.
And, Your Honor, like I said, there are 3 alternative arguments for this court, but it is a rebuttable presumption, but Strickland says you can't rebut it with extra record evidence. So the only thing that you'd be able to rebut it with is something in this record that shows that this jury, in fact, hung their hat on the fact that the judge previously said he was sentenced to death. That would be the only way to rebut
that's not it's not hang your hat. It's whether there's a reasonable probability that here that the problem could cast the verdict into doubt. right?
Reasonable probability of different outcome, but in performing, remember, that paragraph in Strickland that I've relied on is how do we do that analysis? How do we perform the reasonable probability? And in performing that analysis, they say, we presume they follow the law, we do all of those things. Well, if the jury did follow that presumption, there's no indication, there's no way, there's no contrary evidence in the record that would demonstrate they relied on that fact at all. So there's no reasonable probability of a different outcome because an objectively reasonable jury following the law would not have weighted this comment in the slightest. And that's from Strickland itself that gives us that. I do want to focus a little bit on the habeas issue about the Nelson hearing. And I do think that this is probably another important point for clarification, where this court can provide some clarification, and that's that there is a lot of confusion seemingly about 4 different categories of error: fundamental error, per se error under Florida law, structural error under the United States Supreme Court's precedent, and then plain error under federal law. And Kaczmar ends up blending these together. He cites cases where district courts of appeal have held it's per se reversible error to not hold a Nelson hearing, but none that actually hold its fundamental error. And as this court clarified in Johnson, a per se reversible error and a fundamental error are 2 different things. Per se reversible error needs to be preserved. And once you have preserved it, well, then we're not doing a harm analysis. We're automatically reversing. But it doesn't get you past the preservation point. You still must preserve the error. So Kaczmar's concession that this issue was not preserved, or I guess partial concession maybe, that this issue was not preserved would kill that. Because this was a potentially per se reversible error, but it wasn't preserved. There was no ruling. It was never brought before the court. And the 4th District has routinely, from what I could tell, held that if you don't, even when you put in that handwritten request for a Nelson hearing, or not even really a Nelson hearing, complain about your counsel in a letter, if you don't bring that forward before the court, well, then you've waived it. We're not going to reverse on that issue.
And so it's the state's position that this court has never found fundamental error for failure to hold a Nelson hearing?
Never. I couldn't find a case.
And therefore, appellate counsel would not be ineffective for failing to bring a non-meritorious claim.
Right. In this case, a novel argument, because no real precedent supporting it, but even just as a straightforward argument, this wouldn't be fundamental error. So that dispenses with the habeas issue. The only other thing that I wanted to address, and it comes into play with the issue 7, which I'll get to very quickly. The evidence of the sting operation with Detective Humphreys, we've pretty much said, assume deficient performance, and then just do a prejudice analysis. And the prejudice analysis involves the fact that Kaczmar was routinely lying about where he was. That he, and the jury was told in his confession, he told law enforcement, I was miles away fishing at the time. We know that's not in fact the case. He was caught getting gas near his house. The house was subsequently set on fire. There was a tight timeline. You did have Falancia saying, he confessed to me. You had his wife identifying him on the camera. You had the shouting match that occurred between Kaczmar and someone who the neighbor said, I thought it was his father, I think, if I remember correctly. That Kaczmar and his dad were in an argument. All of that evidence is going to be more than enough to get us past the idea that there's a reasonable probability that a jury hearing it would have acquitted Kaczmar instead of convicting him. There was simply too much evidence. And so with that, Your Honors, the state would respectfully request this court reverse the lower court on issue 1 and affirm the remainder of the issues that Kaczmar has presented in this appeal and habeas petition.
Thank you very much.
I think that this court's instruction in Hitchcock lays out what should have been told to the jury, and the whole reason for, I imagine, promulgating those instructions was so that an error like this, a clearly prejudicial error, would not happen. I wanted to distinguish Thurnell. The holding in that case was specific to ineffective assistance of counsel for not presenting mitigation. And the state's seeking to expand it to, this is the test for ineffective assistance of counsel at a penalty phase, which I don't think those two things are exactly similar or should have the same test. There are other ineffective assistance claims that could potentially come up in a penalty phase, like agreeing to erroneous instructions or not objecting to instructions. And I would argue that the test for that has to be something different than reweighing the mitigation and aggravation. Another point, I think, is that it's not solely the jury's decision, right? And it's important to remember that the judge here heard the mitigation, found 15 non-statutory mitigators, and gave them some weight, slight weight. So had he not been placing so much importance on the jury's recommendation, I think the judge could have weighed this and come out with a different outcome. Additionally, in addressing the issue of the polygraph too, this court has previously held that that's not something a jury can disregard, right? And I think this goes to Justice Labarga's point of these are human beings, and that's exactly why we don't allow evidence of polygraph, because it's not reliable, but the public may be under the impression it is. So it's just very prejudicial for that information to be in front of a jury, even given a curative instruction. In sending this case back for a new penalty phase, this court wanted Mr. Kaczmar to have a reputable penalty phase, and this was not that. This was a mess. Also, while Mr. Kaczmar did waive mitigation, his whole reasoning for that was that he continued to declare his innocence, and he wanted an attorney. He wanted to be sentenced to death, so he would have an attorney. So he's still maintaining that Mr. Shea did an ineffective job, which I think brings us back to the Nelson claim. Now, naturally, appellate counsel wouldn't have had the benefit of the lower court's determination of ineffectiveness, but I think that it's something that this court should think about, is that as it played out, Mr. Kaczmar did have ineffective assistance of counsel, right? And had they gone through the Nelson hearing, things would have come out very differently. For the rest of the arguments, I would rely on my briefing.
Thank you very much. The court's adjourned.
All rise.